Okay, good afternoon, everyone. Welcome to the fourth in our series of webinars. This one is an overview of Bill C-31, Protecting Canada's Immigration System. The presentation is by Sherry Aiken with the Faculty of Law at Queen's University. So now, just before Sherry starts, you will see a panel at the bottom right-hand side of your screen titled Questions. So you can type your questions into that panel at any time. And once Sherry finishes her presentation, she'll respond to the questions. And so now we'll get started.
Okay. Good afternoon, everyone. So Bill C-31, the Protecting Canada's Immigration System Act, otherwise known as PCISA for short, received royal assent on June 28th of last year, and most of its provisions are now in force. The PCISA amends both the Immigration and Refugee Protection Act, which I will refer to as IRPA, and the Balanced Refugee Reform Act of 2010, which had not yet been fully implemented when PCISA came in. Now, PCISA introduces significant changes to Canada's inland refugee determination system. On the bright side, it provides for the implementation of the Refugee Appeal Division, which was long awaited, and amends other areas of immigration law, not so much on the bright side, including new measures in the human smuggling and trafficking regime, as well as restrictions on applications for permanent residence on humanitarian and compassionate grounds. The government suggests that overall, PCISA will result in faster refugee decisions, timely removals, greater fairness and integrity in the program, and protect our streets and communities from criminals and unwanted security threats. In my view, PCISA is very much all about closing the door on Canada's humanitarian traditions and represents a significant attack on the rights of refugees. It's also been asserted by many scholars and advocates and lawyers across the country that numerous provisions in this bill constitute violations of Canada's Charter of Rights and Freedoms. And as we speak, there are lawyers across the country working up constitutional challenges of various provisions in the bill. But, you know, before we talk about legal challenges, we need to understand exactly what's included in this bill. And I have to say, it's a very wide-ranging series of amendments that are quite complicated in terms of their interactions and interrelationships. And if you actually try to read the bill itself, your eyes will likely glaze over. So what I'm going to try to do in the time available to us is really distill some of the key reforms and hopefully leave enough time for discussion so that anything that I haven't talked about in my general overview can be addressed through your questions after the presentation. I also want to mention, in terms of background material, that there's one source that I would really recommend people take a look at if you want to get a comprehensive overview of all of the bill's provisions, and that's the legislative summary. Now, legislative summaries are prepared of every government bill. It's standard, but this one I think is quite helpful in terms of explaining all the various provisions and how they changed the previous provisions. So in many cases, this document actually provides the old language from the Immigration and Refugee Protection Act, and then right alongside it indicates what's been changed. So that's useful, and there's the URL for anybody that's interested. And I would also reference a really excellent report by Naomi Alboim and Karen Cole for Maitrey Foundation, which is more of a narrative. It's not so much a clause-by-clause analysis of the bill, but it certainly is a great compendium of all the recent changes, and by the way, not just from Bill C-31, but from a series of other reform initiatives that Minister Kenney has initiated over the last couple of years, and there have been many. So hopefully that can be useful background reading for those of you that want more details. So, starting in on some of the key changes, I'm going to talk, as I mentioned, about a couple of key things: designated foreign nationals, designated country of origin, a little bit about the new Refugee Appeal Division, as well as changes to the pre-removal risk assessment, humanitarian and compassionate application, and then finally trafficking and smuggling. So to start in on the new designated foreign national regime, or DFN for short, and irregular arrivals, here's what's happening. The PCISA creates a new category of DFNs which apply to persons who arrive in Canada as part of a group designated by the Minister of Public Safety as a quote-unquote irregular arrival. Okay? Designated foreign nationals are subject to a different detention regime and are accorded fewer rights than other refugee claimants. Okay? The Minister of Public Safety has the discretion to order the designation of a group arriving in Canada as an irregular arrival for one of either two reasons. First of all, neither the examinations nor other investigations concerning the group can be conducted in a timely manner, or there are, quote, reasonable grounds to suspect that there has been or will be human smuggling for the benefit of, profit of, or at the direction of a criminal organization or terrorist group. And not only that, PCISA permits a designation of an irregular arrival to be made retroactively until March, back to the 31st of March 2009. Okay, so a couple of things to point out right off the top. It's very clear the minister, indeed the Minister of Public Safety, is given broad discretion to decide what a group is. You know, the thought was that when these provisions were first proposed was that clearly these were aimed at, you know, mass arrivals. So, for example, a boat off the West Coast. Indeed, if we had any questions about who the provisions were targeted at, we can see the reference to the 31st of March 2009 would clearly encompass the passengers on the Ocean Lady as well as the MV Sunsea, right? Because we know that the Ocean Lady arrived back in the spring of 2009, the fall of 2009, and then we had the MV Sunsea the year after. So carrying primarily Tamil refugees from Sri Lanka. And, you know, the theory being, oh, when people arrive in a large group, it's much harder for border authorities to actually conduct interviews and figure out who these people are and determine whether they're eligible to pursue a refugee claim. So we need a special regime for these people to make sure that we protect Canada and Canadians from any possible threat that these passengers might pose. So, okay, that was originally supposed to be the rationale for the provisions. Interestingly, the very first time these provisions were actually used after implementation of the bill was not in relation to the passengers on the Sunsea or the Ocean Lady, but rather a disconnected kind of group of people, of Roma refugee claimants, who didn't arrive in groups of hundreds, you know, or even 30s and 40s, but were arriving in, you know, groups of extended family and community members, certainly not the large or mass arrival that these provisions were apparently targeted at. And I mention this not to say, oh, isn't it a good thing that, you know, hundreds of people haven't been hit with this designation. I mention it to highlight the fact that the minister has absolute discretion to decide what a group is. So a group could be, indeed, a very small number of people, not the mass arrival that would seem to justify some exceptional sort of procedure, but, you know, a group that's no larger than the numbers of people that might regularly arrive through an airport at any given time. So that's the first thing I want to mention, that large discretion that the minister has to designate a group, and that the group need not be all that mass or large. Now, what does this designated foreign national regime set out to accomplish? Well, the first thing is it subjects anyone who's subject to the designation to mandatory detention. Okay, so unlike other refugee claimants who are not subject to mandatory detention, they may be detained, but there's very specific reasons for detaining them set out in the legislation. Anybody who's designated as a DFN has to be detained. Now, they are entitled to a review within 14 days after their initial detention. Now, that's actually a good thing, because as the way the detention regime was initially imagined by the government, they were proposing mandatory detention for a year with no right of review until after a year. Now, you have a right of review within 14 days after an initial detention, but then only after the expiry of 6 months, okay? And in contrast to the regime for other refugee claimants, as I mentioned, it's not mandatory, but furthermore, the initial review is supposed to take place within 48 hours, and then 7 days, and then every 30 days thereafter. So if you don't get out right away, you don't have to wait very long before you can hope to have the grounds of your detention reviewed again and hopefully be released. And just to stress, the main reason that justifies continued detention usually relates to the authorities not being certain of someone's identity. Often the case that refugee claimants arrive without identity documents, and they need some time to be able to verify who they are and where they're from precisely. Or it may be that there's a fear the individual will go underground and never show up for their refugee hearing. And one of the best ways of providing reassurance that that won't happen is to release the individual on some sort of monetary bond. And usually that takes a bit of organizing. It's often not necessarily ready right away, but certainly could be ready within a matter of weeks or a month. Now designated foreign nationals, if they're not successful in getting released after the first 2-week period, face a 6-month period before they have another opportunity to seek release. So it represents a very serious incursion on their liberty. Okay, there's more. The designated foreign national regime also denies access to the Refugee Appeal Division. So one of the sort of good points, as I mentioned, contained in PCISA is the fact that it firmly established the long-awaited Refugee Appeal Division. The Appeal Division was supposed to have been put in place with implementation of the IRPA back in 2002, but a series of successive immigration ministers simply didn't bother to implement it. And I mean, it was very intentional. And now we've got the Refugee Appeal Division established, but there's a whole series of restrictions in terms of accessing it. And anybody who's applying and for would want an appeal, if they're a designated foreign national, they don't get one. It's kind of interesting because there's no real logic to denying an appeal to somebody who's arrived in a group. Does somehow the fact that they've arrived in a group make them less worthy of being treated fairly in terms of process? It's hard to really rationalize the restriction here, even with the government's own logic. The whole rationale of having an appeal division is it's a faster, more accessible way of ensuring that the Refugee Board has done its job properly. Everyone acknowledges that applying for judicial review in federal court is a very limited remedy. It's not accessible for many because you require a lawyer in order to even initiate a judicial review application. But more significantly, federal court is not a very good forum for addressing some of the major reasons why refugee hearings can go wrong. With respect to credibility matters, for example, it's really largely ineffective, where the idea with the appeal division is it actually has the ability to convene an oral hearing if necessary and review indeed the grounds upon which the individual's claim was rejected. But if you're a designated foreign national, you don't get access to an appeal. Not only that, although you still have a right to apply for judicial review in federal court, you don't get an automatic stay of removal if you do apply to federal court. And what that means is that unlike every other refugee claimant who has the right not only to access an appeal at the Refugee Appeal Division, but then if they're unsuccessful there, they can challenge that decision in federal court by way of judicial review, and they can count on the fact that the government won't remove them until the federal court has had an opportunity to hear the application and make a decision about it. So there will be no removal pending the federal court matter. Well, if you're a designated foreign national, you don't get that automatic stay of removal. It means that the government can initiate removal proceedings while your case is still being, wending its way to the federal court. And you could be on the plane back to your country of origin. Now, you do have a right to apply for a stay of removal, but once again, you need a lawyer. It's not that easy. You have to be able to demonstrate to a federal court judge that irreparable harm would happen if you were not granted the stay, among other issues. And that's not always easy to demonstrate, particularly on the face of a record from the initial refugee hearing that's not positive, that you lost at first instance. So it's going to be quite challenging to get those stays of removal. Okay, what else does the designated foreign national regime do? It imposes reporting conditions even after someone's refugee claim has been accepted. So, you've been detained potentially right up until the time of your refugee hearing. You have the refugee hearing. Fortunately, it goes well. You're granted protection. You've got that piece of paper that says you're either a refugee or a protected person. But guess what? You still have to report to the government. Sometimes it could be every week, and it can last up to 5 years. So it's not as though all of a sudden you're a protected person and everything's okay. More significant than that, in my view, is the mandatory 5-year wait before you can apply for permanent residence and initiate sponsorship applications for your family members. So what that means in reality, refugee claimants who are designated foreign nationals are often going to be separated from family members they've left back home, spouse, dependent children, potentially up to 8, 9, even 10 years, because it's only after the 5-year period that you have the right to initiate the application for permanent residence and family sponsorship. And as most of you, I'm sure, know, sponsorship applications often take a very long time. So it's not as though in 5 years and 1 day your family members are going to be arriving in Canada. Most likely it's going to be a further several years before family reunification can even take place. And without permanent resident status, there's a whole host of other restrictions that designated foreign nationals will face. Simple things that permanent residents can access. For example, being able to enroll in university or community college and not have to pay foreign student fees. That's huge. Being able to obtain a small business loan in order to start some sort of business. Generally can't do it without permanent resident status. There's a whole series of employment opportunities that will no doubt be unavailable to people who are designated foreign nationals who don't yet have their permanent residence. So it represents a very serious incursion on socioeconomic rights for these successful refugees. The other thing we need to know is that anybody who is a designated foreign national, once they're rejected at first instance by the Refugee Board, will not be able to apply to remain in Canada on humanitarian and compassionate grounds for 5 years from the date of the board's decision rejecting them. So one would imagine if they've been rejected as refugees and they don't have access to the Refugee Appeal Division, and yes, they can apply to federal court, but there's no automatic stay, the chances that they'll actually still be in Canada after the expiry of the 5-year period are probably next to nil. So what the government is saying is the mere fact that you arrive in a group, possibly because you've arrived on a boat, but not necessarily, we are going to afford you way less due process rights through your refugee hearing. And if you fail your refugee hearing, we are going to ensure you're booted out the country as soon as possible with no other possible recourse. So it's a very, very serious incursion on the rights of refugee claimants who receive this designation. So I'm going to move on. That's all I want to say about designated foreign nationals for now. I want to move on to the concept of designated countries of origin, or DCO for short. So this designation is triggered when a country meets one of two quantitative thresholds set out in a ministerial order. Okay? So either a rejection rate of 75% or higher, or an abandonment and withdrawal rate of 60% or higher can trigger a review which results in a designated country of origin. So the idea here is that if there are groups of refugees or any collection of refugees arriving from specific countries, and those claims are rejected at the rate of 75% or higher, then in a given year, then the country that they're from is going to receive a designation. Now, keep in mind, if we're talking about 75%, we're saying that refugees may be coming from somewhere and actually receiving positive recognition at the rate of 25%, which is significant. It's not nothing. It's not like saying, oh, you know, hardly anybody is ever recognized as a genuine refugee from this country. When we say 25% of all claims are recognized from a particular country, that's actually pretty significant, keeping in mind that the overall acceptance rates before the board have been hovering anywhere from, you know, the low to middle 40 percentage points on average for the last many years. In any event, designated countries of origin are going to happen according to this mathematical formula. And what you need to know is that there's now a list, indeed two lists, of designated country of origin. The first list was published in December of last year, and it identified 27 countries, primarily EU countries and the United States, but not Romania, Bulgaria, or Mexico. Then in February, just last month, the Minister of Citizenship and Immigration announced a new list of designated countries of origin and added 8 countries, and those include Mexico, Israel, excluding Gaza and the West Bank, Japan, Norway, Iceland, New Zealand, Australia, and Switzerland. And certainly the most controversial addition in that list is Mexico, which has been a source country for refugees to Canada for many, many years, continues to be a source country of refugees who receive positive decisions. But as I mentioned, you know, the positive recognition rate may not be, you know, 26%, which would be enough to not have it on the list. So Mexico is included. Now, what happens if you're from a designated country of origin? This is what happens to you. You're subject to faster timelines in regard to when your hearing will be initiated before the board. So your hearing will take place between 30 to 45 days after your arrival, compared to 60 days for all other claimants. Okay, so that's pretty significant. Why does it matter? Well, the time before your refugee hearing is usually the time in which you find a lawyer or else somebody else to help you prepare for your hearing. You begin to gather evidence that you may need in order to support your claim. It may be that you need affidavits to prove your identity or to establish that certain things happen to you. So that preparation time is critical. But if you're from a designated country of origin, you have substantially less time to prepare for hearing. Not only that, you're not permitted to apply for a work permit until your claim has been approved by the Refugee Board, or at least after 180 days have passed. Like designated foreign nationals, you're denied access to the Refugee Appeal Division, and you're denied an automatic stay of removal if you seek to apply for judicial review in federal court. You're also denied access to a pre-removal risk assessment for a 36-month period following a negative decision by the Immigration and Refugee Board. Now, most refugee claimants now face a 12-month bar as opposed to a 36-month bar. So that's pretty significant as well. And again, it's the government's way of saying, you know, if you're from a designated country of origin, yes, you're still going to have access to a refugee hearing, but if you're not successful in that first kick at the can, we're going to do everything we can to make sure you're out of the country before you have the opportunity of accessing any other remedy through which you might conceivably be allowed to stay. And I want to point out that many people who don't end up meeting the criteria for protection in their first instance refugee hearing may nevertheless have valid and indeed very strong grounds for seeking the opportunity to remain in Canada. There's all kinds of reasons why someone may need to leave their country or someone may need to seek to stay in Canada that have nothing to do necessarily with a refugee claim, but are other humanitarian reasons or other reasons related to risks that are not recognized in the actual protection hearing. That's why we have these two other administrative remedies, the humanitarian and compassionate application and the pre-removal risk assessment. Now, the humanitarian and compassionate application is a purely discretionary application. Claimants submit it in writing. They actually have to pay a processing fee in order to pursue it. But at least it gives the opportunity of a more broad-based review of all the circumstances of their case. The pre-removal risk assessment, you don't actually have to pay anything for it. And it's the, again, written procedure that the government does, just like the name of it sounds like. It's just right before kicking somebody out of the country, there's a review to see whether there are any extenuating circumstances that should justify a decision to allow them to remain in the country. And I should mention that the acceptance rates through both the humanitarian and compassionate process and the pre-removal risk assessment process right now is very low for rejected refugee claimants. Very, very low. So it's interesting that the government is moving to, in effect, deny access altogether to these two procedures when it's not as though tons of people were actually being allowed to remain in the country anyways. So it really speaks to the point I was making about how this is very much a direct attack on the rights of certain groups of refugee claimants and making it very, very difficult for certain groups of people to ever have any hope of remaining in the country. Now, I want to say a few words that are not addressed directly by the PowerPoint slides that accompany my talk, but are things to just be aware of. I've mentioned the Refugee Appeal Division, the fact that it's established. That's a good thing, no doubt. I'm not going to get into the intricacies of procedures before the Appeal Division, but I do want to point out that they're very uneven in terms of giving the government far greater rights to introduce evidence right up until the last minute, to intervene in the appeal, and basically to use procedures to its advantage at the expense of the refugee claimant seeking an appeal. So the procedures that are actually implemented around this appeal are definitely disadvantageous to the appellant when the appellant is the rejected refugee claimant. And also the fact that this appeal, although it's supposed to be correcting mistakes that were made at first instance, has been envisioned as largely a written, paper-driven process that's certainly not accessible to somebody who is without counsel. The board likes to use the term self-represented. I don't like that term because I think it seems to suggest that it's somehow okay to not have a lawyer, and I don't think it is. If you take a look at just the rules required for initiating an appeal and for participating in an appeal hearing, what you'll see very quickly is that without counsel, it will be very difficult, if not impossible, for someone to ever have any hope of success before the Appeal Division. The other thing to just highlight as well is the restrictions on applications to humanitarian and compassionate grounds applications for everyone, not just DCOs and DFNs, but everyone. There's going to be no humanitarian and compassionate applications initiated if someone has a claim before the Immigration and Refugee Board, including the Refugee Appeal Division, before 12 months have passed after being rejected. Okay, so you've been rejected. You're not a designated foreign national or even from a designated country of origin. You're just, a regular refugee claimant. But you've lost your claim, and you no longer have the right to apply for humanitarian grounds unless, there's one exception, if you can demonstrate that you are facing a risk to life due to inadequate health or medical care. Okay, so that's the only exception. But basically what we're seeing is a narrowing of options for rejected refugee claimants. So I want to say a little bit about human smuggling and trafficking because these provisions will no doubt affect people and indeed have started to affect people as we speak. So PCISA changes the definition of human smuggling. Okay, this is what it now is. No person shall knowingly organize, induce, aid, or abet the coming into Canada of one or more persons who are not in possession of a visa, passport, or other document required by this Act. Sorry, that was, I misspoke. That was the previous provision in Section 117 of IRPA. Okay. Now what we have are new measures that provide mandatory minimum sentences for persons who are convicted of human smuggling of fewer than 50 people or 50 people or more if the person in committing the offense endangered the life or safety of or caused bodily harm or death to any of the persons with respect to whom the offense was committed. And don't worry, I'm going to explain what all this means. This is part 2. The commission of the offense was for profit or was for the benefit of, at the direction of, or in association with a criminal organization or terrorist group. Okay, and it also adds to the list of aggravating factors which courts can consider in determining penalties for trafficking in persons. So what does all this mean? Essentially, it's going to be much easier, well, it will be easier to charge people with the offenses of human smuggling and trafficking. It used to be the case under the previous regime that a possible defense against a charge of this nature was that, you really didn't know that the person was seeking to make a refugee claim or stay in Canada illegally or, didn't have valid documents. There were a lot of possible circumstances that may have prevented you from being charged. The government has closed that off and cast a wider net so that it's very clear under these provisions, and it was still possible under the previous provisions, which, by the way, have been successfully challenged in BC, but they're subject to an appeal right now. But it's very, very conceivable under these provisions that humanitarian workers or family members who help someone to come to Canada without a visa, so they're being smuggled, they're coming, let's say, with, they're coming on a boat or they're coming overland, possibly with false documents, all the different ways that people end up coming to Canada. If you've actually facilitated their travel to Canada, then it's quite clear that you can end up being charged with smuggling. And you'll notice that the dividing line for the offenses is 50 people or less or 50 people or more, right? So that's a fairly large number. In other words, you're not going to be able to say, well, I shouldn't be charged with smuggling because there was only one person. and it was actually my sister-in-law. That's not a defense, because in fact the offense is made out regardless of the number of people. The only difference is that the sentence you receive will vary according to whether it was less than 50 people or more than 50 people. And I want to say something about this mandatory minimum policy. That's an approach to criminal justice that has been in effect in the United States for many years and in some other countries, and is increasingly recognized as being ineffective. Indeed, states all over the United States have abandoned mandatory minimum sentencing because it doesn't work. It's egregiously punitive because it essentially takes away the judge's discretion to consider the individual's actual circumstances and whether there are any mitigating factors that should militate against a harsh sentence. It takes that discretion away, and it essentially provides a cookie-cutter approach to sentencing, something that scholars, lawyers, and others have recognized quite firmly is not a good policy in terms of criminal justice. And what's Canada doing? Adopting the failed countries of the failed policies of the United States. It's quite shocking. And I might mention, with regard to smuggling and trafficking, that anyone actually convicted of those offenses are potentially subject to a fine of $1 million and or life imprisonment. So the judge has already, like prior to PCISA, the discretion to impose very harsh sentences indeed. But the judge also had the discretion not to impose those sentences and to indeed tailor the sentence to the individual circumstances, keeping in mind that the vast majority of people who facilitate any sort of smuggling operation, when it comes to refugee claimants in particular, are not the actual kingpins of some transnational criminal organization. The people who end up coming to Canada with their smuggled passengers are usually often very low down on the food chain. They might be refugee claimants themselves who've agreed to help facilitate the smuggling operation for a discount on their fee. And we're subjecting these people now to very serious criminal sanctions. So I think what I should do is end there because I've talked long enough. That's sort of the highlights or perhaps the lowlights of Bill C-31, now known as PCISA, and I'm happy to take your questions and hopefully have a bit more discussion. So let's see where we are. Okay. So the 180 days for the work permit application applies to all DCO countries. RC retroactively or, okay. So we're, in terms of when the provisions actually apply, that would be set out actually in the regulations. My understanding is that that provision applies after December 15th, but I stand to be corrected. Okay. Okay. Can an individual be a designated foreign national? Well, I think it would be unlikely that someone who's not part of a group, of any kind of group, could be subjected to that designation, because the idea is, at least quite clear in the legislation, that it's a group remaining undefined. So it would be stretching it very far indeed for the minister to actually designate an individual disconnected with anybody else. So my sense is it will be groups of people. We've seen the first designation. It was a group, but it was a small group in relative terms. It wasn't a mass arrival. So what we're seeing is these provisions which, you know, are quite extraordinary in the degree to which they downgrade refugee rights and basic due process, can be applied to very small groups of people indeed, but not likely an individual. Anything else? No other questions? Cat, no, that one I dealt with already. Can an individual, no, we already dealt with that.
Okay.
I think that's it.
That's the only one.
You guys are quiet. So what should we do? Should we wait or?
So if there are no further questions, then we can end the webinar now. And as you know, we post all of our webinars online on the OCASI website. And if you have ideas for future webinars, please let us know. You will get an email off the system shortly with the survey, probably I think tomorrow morning, with just a few questions about the webinar and how it went to get your feedback. So thank you, Sherry, for doing this. We're really grateful for this.
Bye, everybody.
Bye, everyone.